on how to register your relevant providers with ASIC. I would like to begin this webinar by doing an acknowledgement of country, and I would just like to acknowledge the traditional custodians on the land on which we meet today, and I would like to pay my respect to their elders past and present, and I extend that respect to any Aboriginal and Torres Strait Islander people here with us today. My name is Natasha Bronkhorst and I will be your presenter for this webinar today. I work as an analyst within the Financial Advisors and Investment Managers team. With me today, we also have Claire Clegg and Charles Hasler, who will be moderators for our presentation. Claire is a senior lawyer within our Financial Advisors and Investment Managers team, and Charles Hasler is a lawyer and he is within our Enforcement Inquiries and Compliance team. Both Charles and Claire will collate any questions asked during the webinar and they will be asked at the end. In regards to housekeeping, ASIC will record this webinar and we will make it available on our website. As part of this, we will also ask you to send through any questions you have using the question and answer function. As mentioned, Charles and Claire will collate these questions and they will be asked at the end. As we will be making our webinar and the questions public, your questions will not be published so we can protect your privacy. If we can please ask everyone not to use the question the question and answer function for commentary or general chat. And it's just because we think that we will receive a large number of questions and we would like to be able to easily collate them and answer all of them before the end of the webinar. If, however, we get general themes or a lot of questions about the same topic, we will collate them at the end and we will release them using a frequently asked document about this webinar. So for today, the structure of the webinar will follow our info sheet 276 on how to register a relevant provider, and we can break the webinar into 4 sections. The first will be the registration requirement. The second will be the registration process. We'll then talk about cessation of registrations, and then for relevant providers who are duly authorised or authorised by more than one licensee, we'll talk about multiple registrations. We will also talk about some key terminology used by ASIC, including during this webinar. And as a starting point, it is important to note that there are different categories of relevant providers. So relevant providers, or people who are commonly known as financial advisors within the industry, are individuals who are authorised to provide personal advice to retail clients on relevant financial products. We also have provisional relevant providers who are completing their professional year of work and training. And then we have limited service timesharing advisors who are relevant providers who only provide advice on timesharing schemes. Relevant providers can then also be an existing provider. And for existing providers, you needed to have been authorised to provide personal advice to retail clients on relevant financial products at any time between 1 January 2016 and 1 January 2019, and on the 1st of January 2019 not have been banned or disqualified from providing this advice to retail clients. Some relevant providers, including provisional relevant providers, can also be a qualified tax relevant provider. And generally for these individuals, you need to, 1, be a relevant provider, and 2, you can either be a tax agent or if you sort of meet the requirements set out by the minister contained in section 921BB of the Corporations Act, you are taken to be a qualified tax relevant provider. It is important to understand how these categories interact with each other, because when we get to the declarations that are required, they will change depending on what category your relevant provider falls into. For today, we will also talk about personal advice, and when we use this term, we are referring to personal advice being advice provided to retail clients on relevant financial products. It is also important to understand that there is a difference for registration between an authorising licensee and the registering licensee, and the registering licensee will be the licensee that is submitting or applying to ASIC to register their relevant provider. We will go through all the terminology in the webinar, but if you've got any questions, please send them through to the question and answers function as well. I was going to mention as well, as our webinar follows our info sheet, you're welcome to pull up the info sheet from the ASIC website. It's info sheet 276. And firstly, we will be dealing with the registration requirement, which deals with frequently asked questions 1 to 8 on our info sheet. So firstly, what is the registration requirement? So it's important to note that this is an obligation that's been introduced by the Better Advice Act, and it requires that from 1 February 2024, in order to provide personal advice, a person must be 1, authorised by a licensee to provide personal advice, 2, appointed to the Financial Advisor Register, and 3, registered with ASIC. This third obligation is the new obligation, and this has been introduced by the Better Advice Act. It is very important to note that being registered with ASIC is a separate obligation, and it's different to the process that licensees use to appoint their relevant providers to the Financial Advisors Register. So we often get the question, aren't the relevant providers already registered because they're on the register? And the short answer is no. So it is important to note, like I said, the requirement to be registered is new, which means that licensees must separately apply to register their relevant providers with ASIC. I have provided a screenshot on our webinar where we can sort of distinguish between the appointment status, which has been an existing obligation that licensees have always needed to notify ASIC. And we can see there that you will either be current if you're appointed, or you will have a cessation status of ceased if you are not appointed. The new registration status is registration status, and it will reflect whether or not the relevant provider is registered with ASIC. You are more than welcome to go onto the Money Smart website, and you can type into the Financial Advisor Register, and you can use any relevant provider, either your own personal details or one that you authorise, and you can have a look at their registration status on the website now. It is therefore, before we start with the webinar, important to understand the differences between being authorised, being appointed, and being registered. So firstly, if you are authorising a relevant provider, the licensee is ensured permitting the relevant provider to provide personal advice on their behalf for the licensee. There is no relevant ASIC system for this because it's a private agreement between the licensee and the relevant provider. When the licensee appoints the relevant provider to the Financial Advisor Register, the licensee is in essence notifying ASIC of their authorisation. The licensee does this using the appoint transaction, and they are required to do this as soon as possible, but no later than 30 days after the date of authorisation. The new obligation requires licensees to also register their relevant provider with ASIC. This happens when the licensee applies to ASIC to register their relevant provider, and this is also done via ASIC Connect, but they use a registration transaction. The timeframe for which licensees need to do this is as soon as possible, but it has to be before the relevant provider provides personal advice to retail clients. And as I mentioned, the registration requirement commences from 1 February 2024. So in regards to who must be registered, all relevant providers, existing and new, must be registered with ASIC. This does include timeshare advisors, but it does exclude provisional relevant providers. It is, however, important to note that once your provisional relevant provider has completed their professional year and they have obtained their completion certificate from the licensee is required to change their role on the Financial Advisor Register from being a provisional relevant provider to a relevant provider. Licensees can do this by submitting a maintain transaction, and once this is done, the provisional relevant provider is now a relevant provider, and the licensee is required to also register the relevant provider with ASIC. Once the provisional relevant provider becomes a relevant provider, they cannot provide advice until they have been registered. It's also important to note that licensees can apply to register all of their relevant providers with ASIC via ASIC Connect now. In relation to who is responsible for ensuring that the relevant provider does not provide advice while unregistered, the answer is both licensees and the relevant provider. So firstly, the licensee is responsible for submitting the registration transaction. They're ensuring that the relevant provider is registered on an ongoing basis, and they're required to also ensure that the relevant provider does not provide advice while unregistered. The relevant provider also has a responsibility, and they are responsible to ensure that while they are unregistered, they do not provide personal advice while unregistered. We will get to the consequences and penalties if the relevant provider provides personal advice while unregistered a little bit later. In relation to when does a relevant provider's registration take effect, this happens once ASIC records on the Financial Advisor Register that the relevant provider is registered. It's important to note that this does not happen when the transaction is lodged. It only happens once ASIC records on the register. I have once again provided a screenshot about what you can see on ASIC's public-facing register, how a relevant provider's status has changed from not registered to registered. So in this instance, ASIC has recorded that the relevant provider is registered and it is publicly displayed for everybody to see. We can now talk a little bit about the consequences to both the relevant provider and the authorising licensee if the relevant provider gives personal advice while unregistered. So for the relevant provider, they would be breaching a restricted civil penalty provision and they may be subject to disciplinary action. In relation to the authorising licensee, they would have committed an offence of strict liability and they would have also contravened a civil penalty provision. These consequences are quite severe, so it's in both the authorising licensee and the relevant provider's best interest to ensure that all the relevant providers are registered at all times. We do get a lot of questions about tax financial advisors and whether or not they need to have a separate registration. The answer is no. There is only one registration process, and that is for all relevant providers, including timeshare advisors. If your relevant provider is able to provide tax financial advice services, you will notify ASIC of this using the appoint or maintain transaction when you first appoint them to the financial advisor register. If you have questions about whether or not your relevant provider can or should be providing tax financial advice services, we have issued information sheet 268, including a flowchart that set this out. It is, however, important to note that if your relevant provider does provide tax financial advice services, the licensee is required to make a declaration about this when you register your relevant provider. The declaration first talks about the relevant provider providing or intending to provide a tax financial advice services, and then about whether or not the relevant provider is a qualified tax relevant provider. We have provided a separate screenshot about this later in the webinar, so we'll cover that in more detail. So we will now talk about the registration process. And if you are following along by looking at the info sheet, we have covered this in frequently asked question 9 to 17. So the first question is about how deemed registration worked. So it is important to note that not all relevant providers were deemed registered. And for you to have been deemed registered, you needed to have been, 1, registered as an individual tax financial advisor with the Tax Practitioners Board immediately before 1 January 2022, or you needed to have a pending application for registration as an individual tax financial advisor with the Tax Practitioners Board, and this application needed to have been approved after 1 January 2022. And both categories of these people needed to have been a relevant provider immediately before 1 January 2022. Because you needed to have been a relevant provider immediately before 1 Jan 2022, this required you to be current on the Financial Advisor Register on 31 December 2021. It is important to note, however, that therefore, if you were, for instance, maybe on a career break and you were not authorised to provide personal advice on 31 December 2021, or you were a tax agent, you were not deemed registered with ASIC. If you were deemed registered, ASIC has written to all of these advisors and the authorising licensee, and we have notified them of their deemed registration. If, however, you think that you should have received a letter and you have not, you can contact us at registration.inquiries@asic.gov.au. To help licensees and relevant providers through this process, we have also created a flowchart which you can access through our info sheet about whether or not the relevant advisor was deemed registered. In relation to what is the difference between deemed registration and being registered ordinarily, once the registration takes effect, there is no difference. It operates in the same way entire way through. So in relation to how a licensee can apply to register their relevant providers, this is done using ASIC Connect, and the licensee will need to submit a transaction. The transaction is called Registration of Relevant Providers. It is important to note that if you are registering a time-sharing advisor, you also need to use this option. You will only be able to register a relevant provider that you have appointed. So it is important to ensure that you have appointed the relevant provider first, then apply to register them. Licensees can also apply to register up to 25 relevant providers per transaction. To help licensees through this process, we have also created a step-by-step instruction guide on how you can lodge this transaction, and you can find this on our website. We will also be hosting a webinar tomorrow and where we will provide a practical walkthrough. So if you have not already, please register for the webinar, or you can listen to the recording afterwards. As mentioned before, our portal is already open, so licensees can apply to register their relevant providers with ASIC now. We have already seen some licensees starting to register their relevant providers. There is a fee to register the relevant provider, and each application costs $50. This fee is a fee set by government. It's a prescribed fee and it cannot be waived. It is important to note that the application fee is charged when the application is lodged, and it is payable regardless of whether or not the application is approved or refused. So now we'll talk a little bit more about the information that is required when applying to register the relevant provider. When the licensee will be required to provide ASIC with the relevant provider's representative number, their business address, their email address, and their phone number. When you provide the email address, it's important that it's the relevant provider's email address and not the licensee's email address or their compliance team's email address. The reason for this is that the relevant provider will get a notice of registration sent to this email. The licensee will also be required to make certain declarations to ASIC, and they can sort of fall into broadly 3 categories. The first being the relevant provider's fitness and propriety to provide personal advice. The second one is about the relevant provider's compliance with the professional standards. And the third is about the relevant provider's ability to provide tax financial advice services. I would just like to mention again that because a notice of registration is sent directly to the relevant provider, it is important that the licensee ensures the relevant provider's information is true and accurate with ASIC. In relation to what declarations the relevant provider needs to make with ASIC, there is no declarations for this. The relevant provider needs to make their declarations directly to their registering licensee. The relevant provider is required to make a declaration that they are a fit and proper person to provide personal advice. As said before, this declaration is not made to ASIC, it is made directly to the licensee. There are, however, certain factors the relevant provider must take into account when making this declaration, and this is covered in question 15 of the frequently asked question document, as well as later in our slide. It is important to note that there is no prescribed form for this declaration, so it's between the licensee and the relevant provider to determine. The licensee is also not required to comment on any of the factors that went into the relevant provider's declaration. They are simply required to get the declaration from the relevant provider. In relation to what declarations the registering licensee needs to make to ASIC, as mentioned before, they fall into 3 broad categories. First, about fitness and propriety. Second, about compliance with the professional standard. And third, about the relevant provider's ability to provide tax financial advice services. When we talk about how the licensee makes this declaration, it's done by ticking the relevant checkbox on the application form. We'll go through each of these declarations in a moment. So the first declaration is about the relevant provider's fitness and propriety to provide personal advice. So the first declaration asks whether or not the licensee has received this declaration from their relevant provider. As mentioned before, you only need to consider whether or not a declaration has been received. There is no requirement for the licensee to comment about the factors that went into this assessment by the relevant provider. So if you have received a declaration, you'll tick the first box that says, I declare I have received the relevant provider's declaration. If you have not received a declaration, you'll need to tick, I declare that I have not received a declaration and we cannot register the relevant provider. You'll need to go and obtain that first. The second declaration asks about whether or not the registering licensee is aware of any reason why the relevant provider is not a fit and proper person to provide personal advice. So the licensee is required to consider certain factors, and we'll discuss this a bit more. And the licensee is required to make this assessment based on all the information they hold about the relevant provider at that time. So if you are the licensee and you are not aware of any reason why the relevant provider is not a fit and proper person, you would make that declaration. If you are aware that there may be a reason, you would sort of tick the second declaration, and you then have the opportunity to provide further detail to ASIC in the box. You're not required to do so, but it may help us in our assessment. As mentioned before, if you declare that you are aware that there is a reason the relevant provider is not a fit and proper person, ASIC will still grant the registration application. The third declaration is about the relevant provider's compliance with the education and training standards. The declaration asks whether or not the relevant provider has complied with the education and training standards contained in Section 921B sub 2 of the Corporations Act. This is about the degree standard. So relevant providers are generally required to have an approved degree or an equivalent qualification or foreign qualification approved by the Minister. As mentioned earlier in the webinar, these degree standards apply differently depending on the type of relevant provider that you are authorising. So if you are authorising a relevant provider who's also an existing provider and is not relying on the experienced provider pathway, they are not required to have an approved degree until 31 December 2025. So for these relevant providers, you would need to tick that this section does not apply. If you are registering someone who came through the professional year standard, they would already have an approved degree. And for those relevant providers, you would tick that the relevant provider has met the education and training standards. The fourth declaration is about whether the relevant provider has complied with the education and training standards contained in Section 921B of the Corporations Act. This is about the exam. So most relevant providers are required to have already passed the financial advisor exam. However, it is important to note that timeshare advisors does not need to pass the exam. So if you are registering a relevant provider who is not a timeshare advisor and they have passed the exam, you would tick the box that says, I declare this relevant provider has met this education standard. If you are applying to register a timesharing advisor and there is no requirement to pass the exam, you would provide the declaration that says this section does not apply to this relevant provider. The next declaration is about the relevant provider's compliance with the education and training standards contained in Section 921B, subsection 4 of the Corporation Act, which is about the professional year standard. So the professional year standard is 1 year equivalent full-time, and it is 1,600 hours. So of this 1,600 hours, at least 100 of these must be structured training. Not all relevant providers would have been required to do a professional year. So if that is not applicable to your relevant provider that you are registering, you would tick the third box saying that the standard does not apply. If you are applying to register a relevant provider who has done a professional year, you would tick the first box saying that they have met this training standard. The last declaration is about whether the relevant provider provides or intends to provide a tax financial advice services. This declaration also talks about whether the relevant provider is then a qualified tax relevant provider. So firstly, licensees need to understand what is a tax financial advice services, and secondly, who can be a qualified tax relevant provider. So ASIC has set out info sheet 268, the answer to both of these questions, and it's important that licensees understand this before they apply to register the relevant provider. If, for example, however, the relevant provider does not provide any tax financial advice services, the licensee will tick the last declaration saying that the standard does not apply. As mentioned throughout the webinar, it is very important to understand that these declarations apply differently depending on the type of relevant provider that you are registering. So we have created info sheet 277, which sets out each category of relevant providers and how the standards would apply to them and how the declarations would then sort of flow from those standards. Similarly, in relation to whether or not the relevant provider can provide a tax financial advice service, we have set out info sheet 268 for more information. So before you submit your registration application, licensees are encouraged to look at both of these info sheets and understand what declarations they are required to make. We will now talk about the factors that are relevant to determining if the relevant provider is a fit and proper person. So both the licensee and the relevant provider may want to consider these factors on the screen. However, it is important to note it's not an exhaustive list. So some of these factors might include whether the relevant provider has had their Australian financial service licence cancelled or their credit licence cancelled or suspended in the past, whether they have ever been banned or disqualified from providing a financial advice service, whether they've been banned or disqualified from managing a corporation, or whether they have been banned or disqualified from engaging in a credit activity, whether or not they have been linked to the refusal or failure to give effect to an AFCO determination, whether they have been insolvent under trading, whether they've been convicted of an offence in the last year, or whether the Financial Service and Credit Panel has made an order against them, or whether they have issued an infringement notice within the last 10 years. As mentioned, these factors are all relevant to determining whether or not the relevant provider is a fit and proper person, but it's not an exhaustive list. In relation to whether or not ASIC will provide confirmation that the relevant provider has been registered, the answer is yes. We will send out a notice of registration to both the relevant provider and the registering licensee. ASIC will do this as soon as practicable after the registration has been recorded on the register. As mentioned before, we will send this notice via email, so it's very important for licensees to ensure that both their own details are correct as well as that of the relevant provider. There are certain circumstances in which ASIC will refuse an application for registration, and that is generally if the relevant provider has been banned or disqualified from providing personal advice to retail clients. Similarly, if the Financial Services and Credit Panel has made a registration prohibition order against the relevant provider, ASIC will also refuse to register the relevant provider. If one of these circumstances arise, ASIC will provide both the relevant provider and the registering licensee a letter setting out the notice of refusal as well as the grounds on which the registration was refused. We will now talk about how registrations can end, and if you're following along on the info sheet, this is frequently asked questions 18 to 22 in our info sheet. So if we're asking about when a relevant provider's registration will cease, for all relevant providers, it will cease when a banning order is made against them or when the Financial Services and Credit Panel makes a registration prohibition order against the relevant provider. For relevant providers who are not the licensee, if the registering licensee ceases the relevant provider's authorisation, their registration will also cease. This generally happens when the relevant provider moves from licensee A to licensee B. If licensee A used to register them, they would have ceased their authorisation, so their registration will fall away as well. For self-licensed relevant providers, their registration will also cease when the licence ceases to be enforced, so generally when they give up their licence. As a rule of thumb, for relevant providers who were deemed registered, if you have changed licensees since the date of your deemed registration, your registration would have ceased. This means that if you have changed licensees between, rule of thumb, generally 1 January 2022 and now, your registration would have ceased as well. Your new authorising licensee will need to re-register you before 1 February 2024. ASIC has been asked whether or not we will confirm when a relevant provider when a relevant provider's registration has ceased, and ASIC will not ordinarily do this. We will do this only in a limited circumstance, and that is when the Financial Services and Credit Panel makes a registration prohibition order against the relevant provider. In this circumstance, ASIC will provide a copy of the order to both the relevant provider and their registering licensees. It is, however, important to note that for most relevant providers, their registration will cease when they move from one licensee to the other. ASIC will not notify either the relevant provider or the licensee when their registration has ceased as a result of this. Therefore, if you are intending to rely on another licensee's registration or you're waiting for them to update the financial advisor register, it's very important to ensure that you have got robust processes in place so you understand exactly when that relevant provider stops being registered. We'll talk a little bit more about what happens when a relevant provider is subject to a suspension or a prohibition order. So we'll talk about a registration prohibition order first. These are made by the Financial Services and Credit Panel, and if an order is made against the relevant provider, the relevant provider's registrations are taken not to be enforced for the period specified in the order. So if the order says that the relevant provider's registration is suspended for 3 months, their registrations are taken to not be enforced for that 3-month period. If the relevant provider is registered by more than one licensee, the order operates to suspend all of their registrations. The financial advisor register will also be updated to show that your registration status is suspended. It is important to note that at the conclusion of the registration suspension order, the relevant provider's registration will automatically be reinstated. This is, however, on the basis that the registering licensee has not ceased to register them, has ceased to authorise them. So if you have ceased to authorise the relevant provider, their registration under your licence would also have fallen away and there's nothing to reinstate. In relation to what will happen under a registration prohibition order, if the Financial Services and Credit Panel makes an order like this, generally what's happened is that you cannot be registered for a period of time, and any current registrations that you have got in force will be cancelled as well. So similarly, if you have got one registration in force, the order will cancel this one registration. If you have got 2 registrations in force, the order will cancel both registrations. The financial advisor register will also show that the relevant provider's registration status is prohibited. During this time, it's important to note that the relevant provider cannot provide personal advice because they are not registered. So when the registration prohibition order finishes, the relevant provider's registration will not be reinstated. This is because the order had the effect of cancelling the registration. This means that the authorising licensee must apply to register the relevant provider again, and the licensee will be required to provide those declarations to ASIC again. The next question that we want to talk on is whether or not a relevant provider's registration will cease when they change licensees. And generally speaking, for most relevant providers, this answer is yes. However, this does depend on your personal circumstances and how you are registered. So we'll talk about a couple of scenarios. And scenario 1 is where the relevant provider is authorised and registered by one licensee only. Most of our relevant providers actually fall into this bucket. If the registering licensee ceases to authorise the relevant provider, the relevant provider's registration will automatically cease. The relevant provider will not be registered and they cannot provide personal advice until they are registered again. If they're moving licensees, this generally requires the new licensee to first authorise the relevant provider, then appoint them to the financial advisor register, and then apply to ASIC to register the relevant provider. In relation to scenario 2, we've got some relevant providers who might be authorised by more than one licensee, but only one licensee applies to register the relevant provider with ASIC. What happens to the relevant provider's registration will depend on who cancels the relevant provider's authorisation. So if it is the registering licensee that ceases the relevant provider's authorisation, the relevant provider's registration will automatically cease when this happens. This means that the relevant provider must not provide personal advice until they are registered again. If it was a non-registering licensee that ceased the relevant provider's authorisation, the relevant provider will remain registered and they can continue to provide personal advice. For scenarios like this, where one licensee may be relying on the registration for another, it is very important that you have robust processes in place to understand exactly when the first licensee or the registering licensee has ceased to authorise the relevant provider. For scenario 3, we have got relevant providers who are authorised and registered by more than one licensee. In this scenario, if a relevant provider's authorisation is ceased by the registering licensee, the relevant provider will remain registered. This is because they've got at least one additional registration in place. The relevant provider, because they continue to remain registered, can continue providing personal advice to retail clients. In all three of these scenarios, it is very important to understand that the licensee who ceases a relevant provider has up to 30 business days to update the financial advisor register. Because a relevant provider's registration ends when their authorisation ends, not when the register is updated, it is important to understand that during this time when the licensee has not updated the register, the relevant provider may appear registered when they're not. Once again, this is why you've got to have robust processes and procedures in place to ensure that you are immediately notified when the relevant provider's registration has ceased. In relation to how quickly a new licensee can register a relevant provider, the licensee can do this as soon as they've authorised a relevant provider and have appointed their advisor to the financial advisor register. Licensees will appoint a relevant provider to the financial advisor register by submitting an appoint transaction. It is important to note that you do not have to wait for the old licensee to update the financial advisor's register before you register the relevant provider. If you do so, there may be a period in time when the relevant provider cannot provide personal advice. We will explain this concept using an example. So we assume that Zoe is a relevant provider. She is authorised and registered by licensee Y. Licensee Y then decides to no longer authorise her to provide personal advice, but they don't lodge a transaction to cease Zoe's appointment on the financial advisor register. Licensee Y has 30 business days to do this, and they do not do it immediately. During this time, Zoe then starts to work for licensee Z. Licensee Z authorises Zoe to provide personal advice, but they do not appoint her to the financial advisor register or apply to register her with ASIC. Instead, what they want to do is they want to wait for licensee Y to update the financial advisor register. Licensee Y waits 10 business days before doing so. At this time, licensee Z then applies to firstly appoint Zoe and then secondly register her as a relevant provider. ASIC then approves this registration application. For that 10-day period, when licensee Z did not appoint or apply to register Zoe, she was unable to provide personal advice to retail clients. So this is one of the things why ASIC encouraged licensees to update the register firstly as soon as possible, and secondly, if you have authorised a new relevant provider, to appoint and register them as soon as possible. We are aware that some relevant providers are authorised by more than one licensee. So we have provided frequently asked questions 22 to 25 that specifically deal with these scenarios. So the first question is, can a relevant provider be registered by more than one licensee? And the answer is yes. You can be registered by any authorising licensee. So if I am authorised by 3 licensees, all 3 of those licensees can apply to ASIC to register the relevant provider. In relation to who should do this or who should submit the registration transaction, as long as the relevant provider is registered by at least one authorising licensee, the relevant provider can provide personal advice. However, it is important to note that each authorising licensee may decide to register the relevant provider. If this happens, each registering licensee will be charged a registration application fee. So if I'm being registered by 3 licensees, both licensee A, licensee B and licensee C will be charged the $50 application fee to register me. If ASIC approves a registration application, a notice of registration will be provided to each registering licensee and the relevant provider. The relevant provider will get 3 notice of registrations, being that they have been appointed under both licensee A, licensee B and licensee C. The registering licensee will only get a notice of registration for the relevant provider that they are registering. So in relation to when will a relevant provider's registration cease if they are authorised by more than one licensee? As a starting point, it's important to understand that when a relevant provider's registration will automatically cease when a batting order is made against the relevant provider or the Financial Services and Credit Panel makes a prohibition order against the relevant provider. The relevant provider's registration will also cease if the relevant provider's authorization to provide personal advice is ceased by the registering licensee. Therefore, it is important to understand that a relevant provider may be able to continue providing personal advice, even if one of the registering licensees have ceased to authorize them, but it depends on their personal circumstances. So we'll try and demonstrate this using a scenario as well. So for scenario 1, the relevant provider is authorised by more than one licensee, but they're registered by only one licensee. So if the relevant provider's authorisation to provide personal advice to retail clients is ceased by the registering licensee, this is the licensee who originally applied to register them with ASIC, the relevant provider's registration will cease when that licensee ceases to authorise them. This means that the relevant provider is not registered and they must be re-registered again before they can provide personal advice. If the relevant provider's authorisation to provide personal advice is ceased by a non-registering AFS licensee, there is no change to the relevant provider's registration status. Their registration will remain in force and they can continue to provide personal advice. Scenario 2 is where the relevant provider is authorised and registered by more than one licensee. So they're both authorised by multiple licensees and they are registered by multiple licensees. So generally in this circumstance, if the relevant provider's authorisation to provide personal advice is ceased by the registering licensee and they have another registration in force, the relevant provider will remain registered and can continue to provide personal advice. If the relevant provider's registration or authorisation is ceased by a non-registering AFS licensee, the relevant provider's registration will remain in force and they can continue to provide personal advice to retail clients. So with both of these scenarios, the outcome depends on the personal circumstances of the relevant provider. We'll try and explain these two concepts using two examples. So the first example is for a relevant provider, Venata, who is authorised by more than one licensee, but she is only registered by one licensee. So she is authorised by both licensee J and licensee K to provide personal advice. However, only licensee J registers Venata on the financial advisor register. Licensee K has not submitted an application to register her at all. Licensee J decides to cease Venata's authorisation, and as a result, her registration ceases as well. Her authorisation with licensee K continues. It is, however, important to note that because Venata was not registered by licensee K, her registration would have ended when licensee J ceased her authorisation. She cannot provide personal advice until licensee K has applied to register her with ASIC. Example 3 is for a relevant provider who is authorised and registered by more than one licensee. So the relevant provider is both authorised by multiple licensees and registered by multiple licensees. So Adam is a relevant provider and he is authorised and registered by licensee A and licensee B. Licensee A decides to cease his authorisation, and as a result, his registration under licensee A also ceases. However, because licensee B registered Adam, his registration will continue and he is able to continue providing personal advice without a break. We will just provide a quick recap before we open for questions. So we just want to confirm that from 1 February 2024, all relevant providers except provisional relevant providers must be registered with ASIC. It's important to understand that being appointed to the financial advisor register is not the same as being registered. Licensees need to individually go in and register all of their all of their relevant providers using the ASIC Connect portal. Licensees can do that now as the registration portal is open. Because both the licensee and the relevant provider will get either a notice of registration or notice of refusal via email, when you apply to register the relevant provider, please ensure that your details are correct. Similarly, as a rule of thumb, most relevant providers' registrations will cease when they move from one licensee to another. So unless you've got a second registration in place, you cannot provide advice after 1 February 2024 unless you have been re-registered. ASIC has provided some guidance for industry. So as mentioned before, info sheet 276, which this webinar is based on, provides information for licensees and relevant providers about the registration requirement. We have also published info sheet 277, which provides additional guidance on the declarations that are required to be made. As demonstrated before, this can vary slightly or greatly depending on the relevant provider that you are registering. So it's important to have a look at this information. In relation to the practical guidance about how to actually register a relevant provider, we have provided a step-by-step instruction for industry on this, and you can locate this on our website. We are also providing 2 webinars, the first being today's webinar, which is an overview of the registration requirement. And we have got a second webinar tomorrow, which is the practical guide on how to register the relevant provider. So if you have gone in and had a look at the ASIC Connect system and you're unsure how to proceed, tomorrow's webinar is for you. So on that note, Claire, I might throw to you to see whether or not we've had any questions.
Thanks very much, Natasha. That was really, really informative, and I'm sure everyone's benefited from that. As you can expect, we have received a lot of questions. So Charles and I have done our best to collate them on a thematic basis. And I'll go through those now and answer those as best we can. We will collate them in terms of a FAQ specific to this webinar and provide some responses that will be available after the webinar. Okay, so the first question that we'll go to relates to the 1st of February 2024 deadline and whether that can be adjusted at all. ASIC's keen to support industry to comply with this new requirement as best that we can. We encourage AFS licensees and relevant providers to ensure that they collate all relevant information for the registration process as soon as possible and to get those registration applications in without delay and in advance of 1st of February 2024. We'll continue to monitor compliance with this new obligation on an ongoing basis. And we've already noted that we have had quite a few registration applications received to date, and they've been approved already. So it's a good sign. Second question is there a cost to register advisors? And if so, what is the cost? The cost is $50 per application, and this fee is set by government. Is there an avenue for bulk registrations? Yes, there is. And transaction can take up to 25 advisors to be registered at once, but each application needs to be considered on its own merits. So, for example, AFS licensees need to make the declarations in relation to each advisor that they're applying to register, and they can't be completed on a bulk basis. So you can upload them in terms of 25 advisors at once, but it does take a little bit more time to nuance those declarations. The $50 fee applies to each application. So if you're applying to register, say, 10 advisors at once, the fee would be $500. The next question relates to deemed registration. So how do I know if I was deemed registered? If so, if I was, is it still current? So all advisors who were deemed registered should have received a notice of registration in early to mid 2022. AFS licensees should have also received notifications at that time. And as Natasha went through, an individual's registration ceases when their authorisation to provide personal advice ceases. So an example of this is when an individual changes AFS licensees. You can check whether an individual remains registered with ASIC by checking the record on the Financial Advisors Register. So that's live now, and you can see whether someone's registered or not. Will licensees receive an updated list of their advisors who are deemed as registered? No, they won't be. Licensees and advisors can determine whether an individual is registered as a relevant provider by checking the Financial Advisors Register. Please note that if the relevant provider has changed AFS licensees recently, the Financial Advisors Register may not be up to date, as AFS licensees have up to 30 business days to update the FAR with respect to the cessation. Another question we have, just lost her lights, from 1st of February 2024, is it correct to say that all new advisors being appointed under a licensee will need to be both listed as an advisor on ASIC FAR and also updated on a new register? So there's two parts to that question, and the first is correct and the second part isn't. So as part of a advisor's onboarding process, they'll need to be authorised by an AFS licensee to provide personal advice to retail clients on relevant financial products and listed on the FAR as a relevant provider, just like normal. So that process hasn't changed. From the 1st of February 2024, all relevant providers, except provisional relevant providers, need to be registered with ASIC. So it's not a new registration, it's not a new register. All the information is collated on the Financial Advisors Register. So you'll be able to see a registration status as well as an authorisation status on the FAR. Is there any guidance about what the fit and proper declaration should include? So question 4 of information sheet 277 outlines the matters that relevant providers must take into account when making the fit and proper declaration. The form of the declaration is a matter for the relevant provider and their registering AFS licensee to determine. There's no prescribed form. Are firms expected to obtain new police checks for existing advisors? So there's no obligation to obtain a police check to comply with the registration requirement. Financial advisors must make declarations to their licensees that they are fit and proper, and AFS licensees must declare that they've received that fit and proper declaration and that the advisor meets the professional standards. In making these declarations, AFS licensees must consider a variety of matters when considering a person's fitness and propriety, and a police check may help you satisfy yourself in terms of these matters, but it's ultimately a decision for each individual AFS licensee. We've got just a housekeeping question in relation to whether this webinar will be recorded and made available, and yes, it will be. We have another question about what happens if the licensee registers you after the 1st of February 2024. So from the 1st of February 2024, you need to make sure that you're registered. So you can't provide personal advice to retail clients on relevant financial products after this time unless you're registered. If you do, you'll be breaching the law, and as will your licensee. So it's quite important that this obligation is met. How do I know if I've been successfully registered? So the information will be displayed on the Financial Advisors Register. Usually it's quite a quick process, usually 1 business day, but it can take up to 5 business days depending on what's included in the application. And you'll also receive a notice of registration as a relevant provider and as the registering AFS licensee to confirm the registration. How do I deregister? There's no need to deregister a relevant provider. So an advisor will lose their registration with a registering licensee by operation of the law when a registering licensee ceases to authorise a relevant provider. So this will be reflected on the FAR once the registering licensee updates the FAR in relation to the cessation. So just keep in mind that there's that 30 business day notification requirement. So the FAR may be slightly out of date depending on when information's updated. What are the reporting obligations where advisors are not registered? So this is ultimately a matter for licensees to determine if a reportable situation has occurred. But as we've mentioned, there are quite severe consequences for providing advice while unregistered. So please keep that in mind. There's a question come in about when the registration status doesn't have anything included in the field at the moment. And what does that mean? That just means that the person hasn't been registered yet or has had a registration and is no longer registered. So once a registration application is received and that's approved, that will be completed there. Will the new status be included in the ASIC data sets going forward? Yes, they will be shortly. Sorry, I'm just reading through a few that we've already covered. What happens if an AR gets registered now and then moves to another licensee, say in April? Does a new licensee have to register them again as part of the AR appointment process? Great question. Yes, absolutely they do. So when they cease their authorisation with their current licensee, that also ceases their registration. So they'll need to be registered again by their new authorising AFS licensee. We've got a question about the location of the step-by-step user guide for registration. It's a bit difficult to, I guess, give you the web address here, but it's linked to question 10 of Info 276. Hopefully that will steer you in the right direction. If you've been deemed registered, do you still need to register if you change licensees? Is it an automatic transfer? So again, if somebody loses their registration status by changing AFS licensees, they will need to be registered again by their new authorising AFS licensee. There's been some questions about which declaration box to tick in the registration application forms. Our best reference would be to refer you to Info Sheet 277, because it really depends on the individual's personal circumstances as to which declarations you should be selecting. We've also got another question about an error that somebody's receiving, that when they're logging in and attempting to register someone, that they're getting a message that the representative's already been registered. And why would they get that message? We don't have the details, obviously, in this forum, but we can only assume that that person has been deemed to be registered under the transitional provisions. You should have received a notice of registration already in relation to that. If you haven't, you can contact ASIC and we'll look into that for you. You can also check the financial advisor's register to see if that person is registered. That information's live. I can see we're right at time. We do have a few more questions, but I think we might leave it there for today, and we'll collate all of the questions received into themes and we'll provide that to industry for your information.
And just to wrap up, we'd just like to thank everybody for their engagement with this webinar. If you think about a question later and you haven't asked it, or you've got a question about your deemed registration status, can you please email registration.inquiries@asic.gov.au, and like Claire said earlier, we'll collate the rest of the questions and we'll provide a response to them as well for general themes. So thank you very much, everybody, for your time. We appreciate your engagement.